In a medical malpractice trial in New York, after the injured victim's attorney makes opening remarks, does the defense attorney then have to give his opening remarks? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. The answer is no, he doesn't. Now you might be asking yourself, wait a second, I don't understand. If the injured victim's attorney, that's known as the plaintiff's attorney, makes opening arguments, doesn't the defense attorney then have to get up and make opening arguments as well to now deflect what the plaintiff's attorney has said? The answer is that in New York, no, he doesn't have to. Now why is that? Because the defense attorney can wait. He can wait until after the injured victim's attorney has put on all of their testimony, made all of their arguments, put on all of their proof. So now, after they've done all that, put on all of their witnesses, and now the plaintiff's attorney says to the judge, Your Honor, at this time, plaintiff rests. Now the defense attorney has an opportunity to turn to the judge and say, Your Honor, at this time we'd like to make opening remarks. And then we call Dr. Jones as our first witness. So then the defense attorney would have an opportunity at that point to go ahead and make opening remarks to the jury and then put on whatever witnesses he feels are necessary in order to defend this particular medical malpractice case. Now, it may seem kind of weird to think, okay, he's now going to sit and wait and not do anything the entire time that we're putting on our witnesses. Well, that's not exactly true. Because no matter what evidence and what testimony and what witnesses we put up on the witness stand, the defense attorney still has an opportunity to question each one of our witnesses. So now, why as a strategic move would the defense opt to wait until everything is done by the plaintiffs before going ahead and starting to put on his witnesses and making an opening argument? There are many different strategic reasons why an attorney would choose to do that, but I will tell you, in the majority of medical malpractice cases in New York, you will typically see the injured victim's attorney going first, making opening arguments, and then the defense attorney going right afterwards, making opening arguments as well. His goal as a defense attorney is to try and deflect immediately the arguments that have been raised by the plaintiff's attorney. And he wants to do that because recency and primacy is so important for the jury. Now, what does that mean? It means things that the jury hears first, they tend to keep in their mind. Even though the defense attorney may be able to disprove certain things later on, he wants to attack this head on as soon as possible. The only way to do that is to make an opening argument that's right after the plaintiff's argument. So why do I share this great information with you? I share it with you because if you happen to be in court and you're observing this and watching the defense attorney tell the judge, Your Honor, at this time I'd like to hold off making opening arguments until after the plaintiff has rested, now you know exactly what it means. You know, I realize you're watching this because you probably have questions or concerns about your own particular matter. Well, if your matter happened here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a great day.